Hello, I'm Angela Princewill, and in my last few videos, I have talked about the various conferences that you are required to attend as you advance your matter through the family law court systems. And today I want to talk about the trial management conference. So if you're at the trial management conference stage, it is getting real at this point. It means you've attended your case conference, you've attended the settlement conference, and you may have settled some issues, but obviously there are still issues outstanding. And at this point, it's getting real. So this is probably, you're at the final stages of getting your matter advanced to a trial. Um, like every conference, the judge is going to try to explore the chances of settling your case. But if that's not a possibility, then at your trial management conference, again, remember, it is not the trial. No final decisions are likely to be made. And I will go over what sort of orders can be made at a conference. But with the trial management conference, the focus is usually making sure that the matter is ready for trial. So the judge would go over what the parties have ready. So do you have a statement of agreed facts done? Have there been requests to admit served? Confirming if there's any evidence that would be given by way of an affidavit. We would also discuss the expert witnesses some more and confirm if there's any reports that are going to be served, and the timelines for doing all of these things will be set. You will be going over your trial scheduling endorsement form with the judge. You will be expected to have filled out some parts. Both sides would be expected to have completed their parts of that form, and you will go through that with the judge. So he or she will go over also the witnesses. So at this point, you should have all of your witnesses put down how much time you expect you will need to examine them in chief, as well as the other side would estimate what amount of time they need for cross-examination. So the judge would go through this very detailed form with the parties, and then he would eventually estimate how much time that he expects the trial will take. And if he hasn't already done this in the settlement conference, your matter would finally be set down again for the next likely the next trial sit-ins. So by the trial management conference stage as well, you should understand what your witnesses would be testifying to. Do you require sort of any visual aids? Are there any accommodations the courts need to make, and all of that sort of thing? So without your matter settling, most likely after this stage, you're looking at attending trial to end your matter. So that's the trial management conference. And you need to understand that with every conference, your conferences can be combined. So you could have a judge scheduling your settlement conference with your trial management conference if it's appropriate in those circumstances. Now I had mentioned about the orders that can be made at your conference. Just to remind you that, take a breather, don't worry too much. It's not the time for you to put forth all of your evidence, but you also need to make sure that you explore the chances of your case being successful or not. You have that opportunity to be in front of a judge. Most judges are very helpful. They would give you their recommendations and let you know how they will proceed if this matter was being heard in front of them. This is a time at the trial management conference stage, you really, really want to think very carefully about proceeding to the next steps because of the costs and risks associated with taking your matter forward to a trial. But in some cases, you obviously have no option. That's what you have to do, and this is the trial management conference just helps the parties structure the trial. So going back to the orders that could be made at a conference, generally it would be procedural orders. Things like, disclosure, for example, is a big one. You also, orders requiring, expert opinions and the timelines for that. Orders can be made if you haven't already attended your MIP, which is the Mandatory Information Program. Then the judge would order that you do that. if we're appropriate and with proper notice, the judge may make more substantive orders. If it's, things like preservation orders, for example, to ensure that nobody's depleting assets and sort of frustrating the matter if before it even gets to a trial. And of course, if you guys are, if both parties are on the same page on a particular matter and you enter into a consent, then the judge can make that, endorse that, so you can take out your order for those particular issues. So I hope that helps. With that concludes all this the series on the conferences. Again, you would most likely have to attend your case conference, settlement conference, and the trial management conferences. More often than not, it's 3 separate dates. Each conference can be done more than once, so you can go for a case conference and the judge may order another case conference, and they can also be combined where you have you're attending on what date and you're attending for 2 conferences.